be seated. Court is in session. Okay, we ready to bring the jury in? Did you make the decision about the redaction for the exhibits?
Yes, we did.
And based upon knowing your objection to those exhibits, but based upon the court's ruling, are the exhibits in the order that you think are appropriate?
Yes, ma'am.
Okay, thank you. Let's go ahead and bring the jury in.
I'm not asking you to rethink it. Are you letting in all the homework assignments as well, the whole?
All exhibits, those are exhibits 212, 211, 209, 210, and 201, as agreed to be redacted.
What about that?
Okay. Let's go ahead and bring the jury in.
Yes, ma'am.
Jury present, Ron.
Please be seated. Good morning, ladies and gentlemen. I hope you had a good evening. Before we get started this morning, I'm going to ask my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. State, you may call your next witness.
Thank you, Your Honor. State would call Sonia Bowles-Melvin.
Do you solemnly swear or affirm the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor. Ma'am, please do me a favor. Spell your name for us and tell us who you are, where you work, and what you do.
Sure. My name is Sonia M. Bowles-Melvin, and it's spelled SONJA-BOLES-MELVIN, and I am the registrar for Seminole State College of Florida.
What is a registrar?
The registrar is responsible for all of the educational records, academic records of the institution.
And I assume that your institution keeps academic and institutional records.
Correct.
I'll show you what has been marked as State's Exhibit 209 for purposes of this proceeding. Do you recognize that document?
I do.
And is that the type of record that is ordinarily kept in the course of your institution's business?
Yes.
And does it pertain particularly to the defendant, in this case, George Zimmerman?
Yes.
Now, there are two sort of sections along with this. If I may, Your Honor? The first is what I'll call a grade change form. You see that?
I do.
Okay. And this was actually submitted for a particular course in a particular department. What is that department, ma'am?
It is legal studies,
Okay. And it is course of which title?
criminal litigation.
Okay. And the second is a diploma or certificate application, also in the name of the defendant. Can you tell me, is this something that, when would a person fill out a form like this?
When they are ready to be awarded a degree from Seminole State College.
So they fill this out to ask to apply for a degree?
Correct.
Right. And tell me when this form was filled out, and B, if you can tell, when the degree was actually supposedly going to be conferred or was being requested for.
Mm-hmm. Okay, it looks like Mr. Zimmerman applied for graduation during the term of fall, which would have been our fall commencement. And he applied on October 17, 2011.
Okay, so that was when he submitted the application. Does it tell us when he was requesting or thought he would have the degree?
Yes, he thought he would graduate by spring 2012.
Okay. Thank you, ma'am. No other questions, Your Honor.
Thank you, Cost.
No, thank you very much.
May Ms. Bowles-Melvin be excused?
Yes, Your Honor. Thank you.
Thank you very much, ma'am. You are excused.
And I would move at this time States Exhibit 209 into evidence.
Based upon the court's ruling, it's submitted into evidence as States Exhibit 209. Call your next witness, please.
Thank you, Your Honor. Lieutenant Scott Kearns.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May proceed.
Thank you, Your Honor. Morning, sir.
Morning.
Would you please go ahead and spell your name for us? Tell us who you are, where you work, and what you do.
Lieutenant Scott Kearns, Prince William County Police. Last name spelled Kearns, first name Scott. I'm currently assigned to operations, Prince William County Police, Prince William County Police, and prior to that I was the bureau commander for the Prince William County Police Personnel Unit.
Okay. Prince William County where, sir?
In Virginia, sir.
Okay. And does the Prince William County, is there a particular name of that agency? Are you the city police, the county police? What?
It would be county police.
And does that agency normally keep records of people who apply for jobs in that agency?
Yes, sir.
Jobs, both civilian and as a police officer?
With the police department, yes, sir.
And in your capacity as the manager of the personnel unit, would you be the person who would normally be, I'll call a custodian of records of that type?
Yes, sir.
How long does the Prince William County Police Department keep the actual applications of records?
Well, in accordance with the Virginia Records Retention Act, what we do is we keep them for the mandated 3 years, and after which time it's standard practice for us to destroy the records after that period.
Were you asked to investigate whether you had any records as it relates to an application to become a police officer in Prince William County by the defendant, in this case, George Zimmerman?
Yes, sir.
Were you able to locate the actual application?
No, sir, it was destroyed.
I'm going to show you what's marked as States Exhibit 211. And do you recognize this exhibit, sir?
Yes, sir.
Okay. What is that?
That's an extract of what we do is after we destroy, you're talking about this, the first document?
Go ahead.
Okay. After we destroy the records after the period of 3 years, we create a very cursory amount of information on the record that was to be destroyed. Basic information, name, address, date of applied, etc. And additionally, we also send out a letter for those individuals that are not considered further into the process. We send them a dated letter with my name at the bottom regarding their status, and then they're not going to be considered further.
And in this case, what was the date of that letter?
The date was July 8th, 2009.
Now, Lieutenant, I'd imagine you get a lot of people who apply.
Yes, sir.
So is there anything unusual or sinister about just people not getting the job as an officer?
No, sir.
Okay. Thank you. No other questions, Your Honor.
Thank you. Any questions?
And I would move at this time State's Exhibit 211 into evidence.
Will be admitted. State's Exhibit 211.
Morning, Lieutenant Kern.
Good morning, sir.
Your position in the police department is because you're a sworn police officer and have full privileges as such?
That's correct, sir.
Are you currently serving in any kind of investigative capacity?
No, sir.
It's more administrative?
I just recently changed assignments just over 3 days ago. I'm now the watch commander for the Western District Evening Squad. But prior to that, I was with the Personnel Bureau.
So it's not uncommon, I take it, within a given police department to change hats from time to time?
No, sir.
Maybe patrol, maybe investigator, maybe behind the desk?
Yes, sir.
How long were you in the administrative position prior to your current assignment?
6 years, sir.
So you were the administrator then at the time Mr. Zimmerman applied?
Yes, sir.
Do you have any, you have no copy of his application, I take it?
No, sir. It was destroyed.
And you couldn't tell me, for example, who he used as a reference on his application?
No, sir.
You don't have a personal memory of the contents of the application itself?
No, sir.
Because, as Mr. Vanta said, you get a lot of them.
Yes, sir.
A lot of people want to be police officers,
Yes, sir.
as did you, obviously.
I did.
So, if I understand the process then, there is an application, obviously, and then under your records retention policy, after a period of time, the actual record is destroyed and there is a brief extract or excerpt from the application, or from the process, rather.
That's correct.
In this exhibit, which is marked as 211, you are certifying here that you are the records custodian.
Yes, sir.
And that what's attached to it is a business record.
Yes, sir.
I notice, for example, that it's not on letterhead and it's not signed, and it doesn't have any more information on the document other than the actual written contents of it.
That's correct, sir.
This isn't a copy then of the actual letter that was sent in the mail.
It's not the actual copy that was destroyed. That's the document that was used to create the original, in terms of later my signature was placed on it along with the letterhead.
This would have then basically been the word processing document that was printed?
Yes, sir.
And you don't have a specific memory of reviewing or signing this?
No, sir.
This is just one among other documents that are kept in the system?
Yes, sir.
And then this other page of the document, if you can see it well enough from here just to help me know what it is this the extract you're talking about?
Yes, sir.
And in this extract, it includes, of course, Mr. Zimmerman's name and social security number and his address at the time. That would be the address at the time he filed the application?
Yes, sir.
It would indicate ethnicity.
Yes, sir.
It would indicate gender.
Yes, sir.
Is that what that means? G?
I'd have to. Some of them were rather abbreviated and cryptic. Yes, sir. That's correct.
G would be gender, and then Mr. or would be Mr.
Yes.
A guy.
Yes, sir.
Spanish,
That would be any languages spoken other than English.
so that it would indicate that Mr. Zimmerman's bilingual.
It would indicate that he stated that he knew another language other than English. In other words, we didn't confirm that, so this is all self-disclosed information on the application, and we just transpose it onto the spreadsheet. So we didn't validate anything in terms of his Spanish-speaking skills. That was self-disclosed.
I see. Well, as would be the birth date and the social and everything else. Right?
Well, some of those things can be confirmed up front through driver's licenses, et cetera, but Spanish would be an actual test that would be performed later in the process.
I see. Gotcha. And then at the end, there is a column that says COLL, comma, credit history.
Yes, sir.
Do you take that to mean that Mr. Zimmerman had a problem with his credit?
Yes, sir.
And that would be a reason why you wouldn't be accepted as a police officer?
That's the reason why we did not consider him further based on that record. Yes, sir.
It makes sense if you think about it, doesn't it? Because a police officer who has credit problems would be vulnerable to criminals, wouldn't they?
Possibly.
They could be put in compromising situations where they may make a bad decision because of their financial concern.
Yes, sir.
So if somebody has bad credit because of their age and not having a clear established work history or any number of other reasons that shows up as bad credit, he would be, in fact, was rejected.
Yes, sir.
So that would mean, I take it, that when his credit got better, or he was able to fully address that issue to the satisfaction of the department, he could reapply.
It's possible, sir.
In fact, you know of people that have applied once, been rejected, maybe applied again, even with other agencies, and ultimately gotten on.
Yes, sir.
May I have just a moment, Judge? Thank you. Thank you very much.
Yes, sir.
Thank you. Any redirect?
No, thank you. I'm asking to be excused.
May Lieutenant Kearns be excused? You said yes?
Yes.
Yes, thank you very much. You are excused. Please call your next witness.
Captain Alexis Carter, Your Honor.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Captain Carter, if you would, please introduce yourself to the jury. Tell who you are, name, rank, serial number, where you are.
Roger that. Captain Alexis Francisco Carter, United States Army, assigned to 3rd Infantry Division, Fort Stewart, Georgia. United States Officer JAG Corps.
Tell me what JAG Corps means.
Stands for Judge Advocate General. I'm basically a military prosecutor in the Army.
So you're yet another lawyer.
Yes, yes.
Captain Carter, do you also teach courses?
I did at one point, but not currently.
Okay. Would that have included back in spring of 2010?
Yes, I taught a course. Yes.
Where did you teach that course?
Seminole State College.
And what was the name of that course?
Criminal litigation.
Do you remember the defendant, George Zimmerman, being a student in that course?
I do.
Okay. And actually, do you remember what kind of grade you gave him?
I gave him a name.
All right. Tell me a little bit about what type of course that was.
Well, when I got the book, or when I got wind of the course, criminal litigation, I automatically assumed that I'll be teaching it from a more practical standpoint, trial advocacy, things of that nature. But the way the course book was set up, it wasn't really like that. And the time frame in which I had to teach the course, I couldn't really teach it from a trial advocacy standpoint. So it was mostly like a crim law, crim procedure course. We talked about the law, elements of the law. We talked about criminal seizure, the constitutional rights, Fourth and Fifth Amendment, things of that nature.
Okay. Did you almost do any kind of what I'll call mock trial sort of thing?
Not really. Not in that course. We didn't have the time for it. Again, it just kind of focused on the elements of the crime, and we would go through hypotheticals where we would ask the students certain questions regarding certain cases and things of that nature.
You mentioned your course book.
Sure.
I'm showing you just what's... Is that your course book, titled Criminal Law and Procedure?
Yes.
Okay. And I'm showing you what's in evidence now, or been marked as State's Exhibit 210. Is this a sort of subsection, very small section of this very big book?
Yes.
Okay. And that's a chapter specifically pertaining to what?
Self-defense.
Okay. And the second part of State's Exhibit 210 is what?
It's a email homework assignment from George. It was the first homework assignment that I gave to all the students.
Okay. And is that
The rest of it actually additional homework assignments?
Yes.
Your Honor, I'll move State's Exhibit 210 into evidence at this point.
Are you moving the book or the excerpt?
Just the excerpt in.
Okay, they'll come in as a composite exhibit 210.
Thank you, Your Honor. Talk to me a little bit, Professor, about what kind of student you remember the defendant to be.
You know, you always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
You mentioned that, and we talked about State's Exhibit 210 as an excerpt from the book about self-defense. Obviously, you were teaching this course in Florida, so tell me what sort of things you addressed as it relates to the law of self-defense in Florida.
Right. So, you know, the way the book is comprised, obviously the publishers aren't from Florida. They didn't really put Florida-specific things, but I wanted to teach the class from a practical standpoint where these students can really relate and take something from it and apply it to their own lives. You know, with Florida and other states, they have what's called the stand your ground law, which evolved from the Castle Doctrine through case law.
And did you cover that specifically?
Yes.
Did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
And did you address the particularities of... Strike that question. Bad question. Professor Carter, what can you tell us about how long you spent as part of that course covering ideas like self-defense and standing?
Right. You know, self-defense is a affirmative defense. It's a big self-defense. It's not one of those things that you're going to just whisk through in a day, or after you teach it, you're going to neglect from bringing it back into the classroom. So it was something that I constantly iterated. I was the type of professor that before I gave any tests, I gave a review for the test. And it was something that I think the students really wanted to know about. It was so practical that they were very much engaged in class discussion regarding the issue. So I remember, talking about it, quite a few times, not just on one particular occasion.
Thank you, President. That's all the questions.
Okay, thank you. Cross?
Excuse me a second.
Sure.
Good morning, Mr. Carter.
Good morning.
My name is Don West. I'm one of the attorneys for Mr. Zimmerman. You see George over here?
How you doing, George?
And Mr. O'Meara's co-counsel.
Morning, Kevin.
Hayes.
How you doing?
How long have you held your current position in JAG Corps?
October would be 3 years.
And you taught at Seminole State College, was it beginning the semester of January 2010?
Yeah, so it would have been from January 2010 time frame to probably, I don't know, May.
Was it just the one term?
Yes, I only taught one class, and that was it.
Mm-hmm. And what did you do after that?
Right around that time, well, I was also working as a PD. I was at the Public Defender's Office during that time, full-time as Orange County Ninth Circuit. So I went back to work, and I left for the JAG Corps for training October 2010. So I went back to work full-time to the PD's office, and then went off to the JAG Corps.
Were you working for the Public Defender's Office in January of 2010 while you were also doing the adjunct professor?
Yes.
I got you. Okay. Do you remember when you started with the PD's office?
So that would probably be November 2009.
Was that shortly after you became admitted as an attorney?
Yes.
Admitted to the bar?
Yes.
So that was your first job?
It was.
As a lawyer, with the Public Defender's
It
Office?
was.
And then you took on the responsibility of the class as kind of a side job?
Yeah, I hopefully one day I could be a law professor, and I like teaching. And the cool thing about that job, teaching, was that a lot of the things that I have to know or had to know every day for my job as a PD was reinforced by educating others.
So when you made the comment that your approach to the class was really from a practical standpoint, you were talking about how this stuff works in real life?
To the extent that you can. It's been said that there's law on the books and law in action. Anybody can tell you what a recipe is, but if you get in the kitchen and don't know what you're doing, you're going to mess up the recipe. So understanding the law and how it's applied, especially when you're dealing with crimes, is so different than anything else. Any fact or change in fact can change the outcome, so that's what I meant.
So even though there might be thousands of individual facts, it could be just one or two that may have significance?
Well, no, all facts have significance. You generally look at things from the totality of the circumstances, but there's certain things that, through case law have been seen to give more weight.
Sure. The totality of the circumstances is you look at the sum total of the evidence, I take it, and then also apply common sense.
Right. A reasonable person standard is what that's generally referred to.
In fact, interestingly, it's the reasonable person standard or the reasonable belief standard which squarely is part of self-defense.
That, yes, you can say.
And we'll talk about that more in a minute. But the work that you're doing now,
Yes.
are you prosecuting or defending?
Prosecuting.
Just prosecuting?
Just prosecuting.
Do you have the opportunity to defend?
No, I do not right now in this position that I am, but the way the JAG course is set up, they put you in a certain position, and throughout your career, you move on to different things. Before being a military prosecutor, I dealt with administrative law, federal regulations, interpreting of regulations, giving legal reviews, things of that nature. So as you progress, they move you on in almost like a little circuit.
So that would include defending at some point, perhaps?
Possibly, if I chose it. The Army sometimes cares about what you want, and then sometimes it's just the needs of the Army. So wherever you're best suited, your skill set, and wherever they need you is where they're going to put you.
Is this your career?
I'd rather not comment on that right now.
Fair enough. Let's go back, though, a little bit to the class that you taught.
Yes.
You commented that the course book that you used, well, first of all, you didn't write the book.
No, I did not.
It was a book that was suggested? Or?
Suggested. I think the previous professor used that book, and when I spoke with the director of the legal department, they said, hey, this is the book that we normally use. Take a look at it. It seemed pretty straightforward, standard book that you would see in a criminal law course.
But it was not Florida law.
No, not specifically. I think they probably maybe reference majority, minority of states, but I don't think they ever probably talked about Florida specifically in that book.
Oh, I was just looking for the other exhibits for a second.
I have them.
Let me take a look. And see
Sure.
what we got there. So the textbook that you used,
Sure.
was not specifically focused on Florida law as much as it was sort of a general discussion of a great many topics within this broad subject of criminal litigation and procedure.
Yeah, but then, I try to supplement that with other materials and things of that nature, discussion to focus them on Florida distinctions, because I felt it was important. Even with respect to other criminal procedures and things of that nature, I felt giving the students some sort of focus, concentration on Florida law was important, so I did that.
So, for example, in part of Exhibit 210, it's an excerpt from the book that says self-defense. And I'll have you just
Sure.
take a look. Just that this isn't a specific discussion of Florida's self-defense statutes or what has been characterized as stand your ground.
Negative.
So that's true, it's not.
Yes, that's true. It is not.
Okay. So your discussions then that would be more focused on the laws in Florida would have been in the class,
Yes.
not in the textbook.
Correct.
Okay. As a member of the Florida Bar, then you took the bar exam and had to learn Florida law in addition to the more broad general principles.
Yes.
So you had an understanding of Florida law as it relates to self-defense, specifically because of the Florida statutes.
Yes.
Just for the jury's benefit, a statute is a law that's been passed by the legislature and
Codified.
codified. So
Right.
when we say a statute, that's what's written in the law book.
Yes.
So the law of self-defense is written in Chapter 776, Florida statutes.
I'm not sure the chapter and verse, but if you say so, yes.
Do we have it just to take a look? This is not a trick question.
No, it's fine.
Is it on your? We'll come back to that
Sure.
in a second. But the idea is that the laws that are passed by the legislature and then usually signed by the governor and then become law are known as statutes, and they're in the law books.
Yes.
And that then becomes the law of the particular state where the legislature has acted.
Yes.
And you are familiar, generally, again, I won't ask you the specific wording, but you're generally familiar with the law of self-defense in Florida.
Yes.
You talked a moment ago, for example, how the stand your ground had evolved from the castle doctrine.
Yes.
Stand your ground is sort of a nickname for the statute. The statute itself isn't titled Stand Your Ground.
No, I don't think any legislator would write that such a way, but it's a nickname.
So the is the word codification. The codification of the castle doctrine became Florida's Stand Your Ground law insofar as the use of self-defense.
You can say that, yes.
The castle doctrine is the notion that if you are in your castle, in your home, and you are attacked, you have no duty to retreat. Even if you can. You have no duty to retreat. You may meet the force with force to defend yourself.
Yes.
Am I right generally on that?
Yes.
And then by the evolution of that doctrine into what's been generally characterized as stand your ground, what it did, basically, was allow someone to defend themselves outside their home if they are attacked,
Correct.
without the duty to retreat.
Correct.
Before that, if you weren't in your home and you were attacked, before you could use deadly force, you had to retreat if you could.
Yes.
If you safely could. So in other words, if there's an attack outside, you have to sort of assess the situation, decide.
Let me hear the rest of the question, and then you may approach.
Under the old law, with the duty to retreat, if you weren't inside your home and you were attacked, you would have to assess the situation and make a decision at that moment whether or not you could safely get away before resorting to force.
Yes.
You may approach.
Thank you, Mr. Carter. We're back. The discussion that I'm having with you now about the Castle Doctrine and this law that's become known kind of by the nickname Stand Your Ground was the part of your classwork that wasn't contained in the book. Is that right?
Yes, it was not contained in the book.
Because of your training as a lawyer, having passed the Florida bar, been admitted to the Florida bar, and indeed working in the public defender's office, you were using that information and your understanding of Florida law to talk about these issues with your classes.
That is correct.
Okay, so what we were talking about then was the evolution of the Castle Doctrine into what the legislature did some, like 7 years ago, 6, 7 years ago, something like that, into what's been known as Stand Your Ground. So
Right.
That's sort of the focus.
Right.
Okay. The Castle Doctrine was this idea that if you were in your home,
It's actually, yeah, same objection.
I think a clarification needs to be made if his answers to these questions are based upon his personal knowledge in his profession or it's what he taught the class. Can you make that distinction?
Say again, ma'am.
Whether or not your answers to these questions are based upon your knowledge as an attorney in your practice, or are they also something that you taught the class?
The evolution of the Castle Doctrine?
That's the question.
Yeah, that would be something that I hit on in the class.
And you may proceed. Objection overruled.
so what that means basically is that when you are at the Castle Doctrine, when you're in your home and you're attacked, you don't have to worry about whether you can get away. You may meet force with force.
Right.
Sort of a... And then what happened when the statutes changed a few years ago into this what's been known as Stand Your Ground, basically the Castle Doctrine of no duty to retreat was simply authorized in locations other than your own home.
Right. I think what would happen is the presumption change. You know, if you're attacked in your home, there's a presumption that you're in fear of your life. A lot of times attacks happen at night. You're scared. You've been woken up by something. So there was a presumption that you were in fear of your life. So that's how that came about. And then it extended outside of the home. But there wasn't that same presumption. That same presumption doesn't exist outside of a home. It's dwelling, residence, I think your vehicle is where that presumption is. But outside of the home, there wasn't that same sort of presumption. Hope that makes sense.
Well, I know you're taking us to school, so let me clarify a couple of things. You're suggesting that when the attack occurs in certain locations, in addition, is there no duty to retreat, but there's sort of a presumption that if it happens, that you will be in fear for your life.
So if you're in your home, that's in your home. There's a greater indicia that person had a reasonable fear of death or grievous bodily harm.
Okay, but if you're in your home and I don't want to go too far away from why you're here testifying today, but I want to clarify, though, that part of self-defense is, under any circumstance, the reasonable belief that you have to act to avoid imminent great bodily harm.
Oh, yes. No question to that. So
There's an objection.
I'm sorry.
My objection is that the framing of the question is counsel's version of the law. And
I'm going to sustain the objection, and and state to the jury, at the end of the conclusion of the evidence of this case, this court will give you instructions on the law that you are to follow and apply to the facts as you find them. Your questioning needs to be as to what he taught the class, not a general discussion on what the law is.
Yes, ma'am. Thank you. So when you taught the class, what is the core concept of self-defense when you can use deadly force?
When you have a reasonable apprehension of death or grievous bodily harm. And the term reasonable obviously has two components. So there's a subjective component, meaning that I feel like I'm in fear. In my mind, I feel like I'm in fear of death or grievous bodily harm. But when stuff hits the fan, you're judged by jurors. And your actions have to meet a reasonable standard objectively. So whether or not a reasonable person in your position would have felt the way you felt.
All right, so what you would explain then to anybody that was there that day would be that on the issue of the reasonable fear, it's both subjective and objective. The subjective part is crawling inside the person's head to see what they were thinking and would it be reasonable to them that they would fear for their life.
Right, and that's why the totality of the circumstances are important. Mm-hmm. For example, if you approach me right now in broad daylight, whatever the case is, I probably wouldn't have that much fear. But, you know, the lights are out, I don't know what's happening, I feel someone grab me. Those are circumstances you need to consider, and whether or not someone had a reasonable apprehension of fear.
So the first part then is trying to understand as best you can from the totality of the circumstances whether that person was in fear in their own mind. Did they think that serious bodily harm was about to happen?
Right.
And then you're saying then there's a bit of a shift. And then in order to see if that's reasonable, then the trier of fact, if you will, the jury then looks at this idea. Does it make sense that somebody in that person's situation, with all of the circumstances, would fear that they were facing imminent great bodily harm?
That is correct.
Nowhere in the discussion of self-defense is it required that the person being attacked actually be injured. It's really the issue of what they think is going to happen, not what's actually happened. Is that right?
I'm going to object again.
Okay. The court will instruct the jury on whatever the law is at the end of the case, and that is the law that you are to apply to the facts as you find them. Your discussion today is limited to what you have taught in the course.
Yes, I understand.
Mr. Carter, the presumption is that any question that I ask you today is either to clarify an answer that you've given, to explain the legal concept, or connected directly with the way you would explain these things to your students.
Right. I understand that.
I'm not going outside the scope of that.
Understood.
So what you just explained is how you would explain this self-defense concept works in Florida.
Right. And it's fluid. You know, the law as it applies isn't static. Like I said, any change in a certain fact can weigh differently in terms of whether someone acted reasonable. And, you know, to illustrate that, I would put up examples on the projector. I would have YouTube videos and pause it frame by frame. Okay, what's happening now? You know, what is this person justified in doing? What are they not justified in doing? And so you can see that, you know, things can change in a matter of moments.
An encounter that doesn't appear to be deadly can turn deadly pretty quickly in your mind.
Oh, yes. Yeah.
On the issue of injuries, though, when you talk about that with the class and your understanding of the law, is that the focus is what's going on in the person's mind, not whether they have actually been injured. It's the fear of the injury, is it not?
It's imminent injury, imminent fear. So the fact alone that there isn't an injury doesn't necessarily mean that the person did not have a reasonable apprehension of fear.
Mm-hmm.
The fact that there were injuries have a tendency to show or support that that person had a reasonable apprehension of fear. But the fact that there wasn't an injury at all doesn't necessarily mean there was a reasonable apprehension of fear. You know,
you don't have to wait until you're almost dead before you can defend yourself.
No, I would advise you probably don't do that. Yeah.
And I take it, when you're under attack, you never really know where that moment will be.
No, unfortunately, you don't. And that's not even something from our. That's something that I think a lot of the students grasped. You know, I think we've all, and they have all probably had situations where, you know, a tussle maybe became more than just a tussle. So things can change.
For example, things can change that a situation that may not have appeared to be deadly or the risk of great bodily harm at first can develop into that.
Yeah, and we also talked about imperfect self-defense, where you may have started out being the person that was attacked, but for whatever reason, you took it a step forward, and now you're the aggressor. So that dynamic between, you know, two people involved in a fight or a scuffle, that could change.
You use the term imperfect self-defense.
Right.
Is that the notion that sometimes the tables can turn?
It means that, or also means that the person acted unreasonably in countering the force that was applied to them or approached with them.
Hypothetically speaking, this discussion that you started, if I'm approaching you,
right. So if you're approaching me,
and let's say that I push you.
Yeah, it'll be a little extra if I picked up a video camera and knocked you upside the head. That'll be a little extra, and that would probably be an imperfect self-defense.
So let me see if I'm clear. What you would explain then would be, for example, I'll use the hypothetical that we started here. So if you and I were facing each other, and I pushed you or bumped you, and you reacted in great disproportion to what I did, then it turns, and you could put me in fear for my life, and then I would have the right to defend myself at that point, even though, under the hypothetical, I may have started it.
Yes.
So in that situation, I would be trying to figure out what's going on. How far are you going to go?
Yes.
How much danger am I really in?
Yes.
And under that scenario, would it be reasonable that if I were screaming for help and you didn't stop over a period of 10, 20, 30 seconds, that I screamed for help, making it clear I wanted no part of this, then I would have then an appreciation that you weren't going to stop.
Judge, I'm going to object to the continuing and the specificity of that hypothetical.
Sustained.
Without the specific details that I'm talking about, that's what you're talking about, in a sense that it really doesn't matter. The focus of the self-defense is at the point that the force is used. And it's only really a relatively minor consideration as to what actually started it.
Objection again as to counsel positing things.
Right. If you will rephrase your question, because you begin it with the former hypothetical that this court sustained. So if you'll rephrase your question, please.
I will. I'll try. Thank you. When you're talking about what you call the imperfect self-defense. What you're really talking about is when you're involved in a situation with somebody, even if you start it, but the tables get turned, and then all of a sudden you're the one that's being attacked with far more force than you used. That's the scenario I'm talking about.
All right, so let's repeat back what you're asking. So, basically, in a sense, if someone initially feel that they were being threatened, and they countered that threat with a force that was disproportionate to the force that was directed towards them,
Right.
yes, that would be an imperfect self-defense claim or imperfect self-defense scenario.
So even under that scenario, the person that may have started it with some lower level of force, and the table turns on them and there's a great level of force, a disproportionate level of force, they have the right to defend themselves.
Right.
Actually, again, we're continuing number one, the same hypothetical. Number two is too specific to.
I'm going to overrule on that one, and the answer was given.
I didn't hear the answer. Could it be read back? You agreed?
Yes.
May I have just a moment? Thank you, Your Honor. Captain Carter, thank you.
You're welcome.
Any redirect?
Carter, as you discuss in the context of all this, is when you're talking about the self-defense law, the idea of claiming it when you. Yes, Your Honor. The idea of claiming it when you have provoked the action. That enter into the discussion?
Objection, Your Honor. Maybe be heard at the bench.
Yes. You may proceed.
Thank you. If I could, you were talking about the imperfect self-defense. Is
Right.
that discussion of sort of provoking use of force? Is that included
Say again?
in your concept of imperfect self-defense?
Right.
Where you talked about from starting as an aggressor to moving to something else. Is that sort of provocation? I mean, is that the concept you're underlying with that, or is that not what you're talking about?
What I'm talking about when it comes to imperfect self-defense is a situation where you do not meet the force that, or the force that you are encountering, you meet that force disproportionately. It's excessive force.
So, I guess then the ultimate level of force in these scenarios is deadly.
It's deadly force,
Like a gunshot.
like a gunshot.
No other questions, Judge? Thank you.
Thank you, Captain.
Thank you. May Captain Carter be excused?
Yes, sir.
Thank you very much, Captain Carter. You are excused. I'll call your next witness, please. Anybody need a recess? No. Call your next witness, please.
Call Jim Krinsky, Your Honor.
Raise your right hand. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Thank you.
You may proceed.
Thank you. Mr. Krinsky, would you please go ahead and spell your last name for us? In particular, tell us where you are, where you work, and what you do.
The spelling of my last name is K-R-Z-E-N-S-K-I. And I'm the Administrative Services Manager for the Sanford Police Department. I basically oversee all the administration of the police department and report directly to the Deputy Chief.
And by administration, does that include the records that the department keeps and maintains?
Yes, I have 4 records technicians that report to me.
Okay. So I'm showing you what State's Exhibit 212. Is this one of the types of records that you just referenced kept by the Sanford Police Department?
Yes, sir.
Okay. And you've seen records like that before?
Yes, sir.
And what is it?
This is the Sanford Police Department writer release form.
When does a person fill out a form like that?
When they request to ride along with the police officer.
Okay. And was this filled out by a particular individual?
Yes, sir. There is a particular individual here.
And who was it?
George M. Zimmerman.
And when was it filled out?
It was filled out, according to this, on 3/15/2010.
Okay. And does the person indicate whether or not they have a reason for wanting to go on these ride-alongs?
Yes, sir.
And what is that reason?
It states here, solidify my chances of a law enforcement career, I believe, a career in law enforcement.
Thank you. Your Honor, I'd move State's Exhibit 212 then. No other questions.
Okay, it'll come into evidence in State's Exhibit 212. Cross, please.
Very briefly, Your Honor, thank you. Morning, sir. How are you?
Good morning, sir.
You, of course, reviewed all of your available records to come up with the one time that Mr. Zimmerman sought a ride-along with a police officer, correct?
Yes, sir. We searched for this record. We have literally hundreds of these, yes, sir.
Sure. And there was only the one where Mr. Zimmerman did that back in 2010?
Yes, sir, to my knowledge.
Never requested it again?
To my knowledge, no.
Were you aware at all in your records that Mrs. Zimmerman had responded after that ride-along, talking about the officer that he had rode along with?
Not directly, sir, no.
Not in any of the records that you keep that when you're looking for that record?
No, sir.
Okay.
I didn't find anything related to this right along other than this form right here.
Okay. Then I have no further questions. Thank you, Your Honor.
Thank you. May Officer Kozinski be excused?
Yes, Your Honor, please.
Okay, thank you. You may be excused, sir. Call your next witness.
Could we approach, Your Honor?
Yes. Ladies and gentlemen, the next witness that is going to be called is going to be appearing by Skype, and that's not scheduled to happen till 11 o'clock today, so we were a little ahead of schedule. So instead of just sitting in the courtroom or starting with another witness and stopping at 11, we're going to take a recess from now until 11 a.m. So if you'll please put your notepads face down on the chair and follow Deputy Jarvis outside the courtroom. Please be seated. Court will be in recess until 11 a.m.